that position used to happen. My name is Angel Reynolds. I'm the juvenile defense attorney at the Minnehaha County Public Defender's Office. It used to be that it was a rotating basis, so if there's 20 attorneys in the office, you are on that rotation maybe once a year. And that's really important because I believe it's good for underserved. It was in the summer of 2010 that I was on that rotation and really enjoyed it. And at about the same time that the Annie-Hasty Foundation was coming into county and talking about reforms. And so I mentioned to Tracy Smith that I would love to do juveniles all the time. And also Tracy said, okay, you can. And so that's what I've been doing ever since. When I first started doing it, I felt very unprepared, and I was. And about the same time, the National Juvenile Defender Center sent a invitation for someone who felt they wanted to come to their national conference in October of 2010, and I went to that. And it was so inspiring, and I came back with so much information and really excited to start tackling things in my position. I then created a relationship with the National Juvenile Defender Center. I'm now an advisory board member for the Midwest section. They provide me with so much information and education. Just like the book we received today, I have piles and piles of them, and they've been great resources. So I'm pleased to introduce all of you to the same group by introducing their managing attorney, Mr. Tim Curry. Tim has been their managing attorney since April of 2012. Before that, he was a supervising attorney at the DC Law Students Court and also the E. Barrett Pettyman postgraduate fellow at Georgetown University. In both of those positions, he defended juveniles as well as supervised the practice of third-year clinical students. Prior to earning his law degree, he worked with the War Crimes Research Office in Washington, D.C., as well as the Botswana Center for Human Rights. Before that, he engaged in various humanitarian relief and worked with refugee organizations in West Africa. He holds a Master of Law and a JD, as well as a BS in broadcast journalism. So I hope that all of you enjoy this presentation, and I'm sure he'll invite you to reach out to them on any cases that you had. I will send an email and have a response with lots of resources within a very short period of time. So please use them as a resource for yourself in your practice field.
Thank you. Before we get started, I know that Liz had asked kind of who was in the room, but some more people came in, and I get a sense from you all. How many of you are actually public defenders? And how many of you private attorneys include criminal cases? And of this group, either public defender or private attorney, how many of you currently carry a juvenile case? And I'm guessing the rest of you do juvenile cases from time to time or through rotation. Or have any. In any case, I think it's important for all of us when we're talking about defending juveniles is to think about why do we do that and how is it different than defending adults. In all of my time defending both adults and kids, the more I work with kids, the more I learn that they're very different. And there's a lot that I don't know about how to properly defend a child. And every day, even to this day, I'm still learning new things as I go along. And I encourage us to think about that. We're all lifelong learners. There's always something that we can pick up every day to better serve our clients. And so that's why it's incredibly important to have kind of conversations like this. Think about what it is that I can do better to serve my juvenile clients. So I'm asking you just to take a second to think about why am I a juvenile defender? Or why would I defend a child? Why is that different from an adult? And when we ask people that question around the country, why do we care about juvenile cases? Some of the common ones that we get, responses we get is because you really make a difference in a kid's life. There's this tradition around the country that juvenile court isn't as important. Juvenile court is some kind of kiddie court, and that the consequences aren't so severe. That belief system is absolutely outdated. Kids face years of detention from their involvement in juvenile court. They've been removed from public housing for juvenile adjudications. They have faced obstacles to employment, to education in their current systems, to the ability to higher education and obtain federal loans. They have obstacles to military service. There's a whole host of collateral consequences that will follow children for not just the short time they're involved in the juvenile justice system, but for their early adulthood and into other parts of their lives. So it's really important that if you take this early intervention as an attorney, as a defense attorney, you can really make some difference with children. The other thing that we hear a lot is those lawyers who are really engaged in juvenile court find that they can be powerful advocates in those courts, and they can really affect change in this mentality with kitty court that often focuses on feelings and cultural practice rather than due process. And as a juvenile defender, if you're in there thinking of due process and the law, and you're living with armed with those tools, you can often be a very effective advocate because it's really difficult to say, I'm not going to follow the law. It happens, and we fight against it every day, but the more we fight about it, the more we try to change that culture, the more we try to inject due process back into juvenile court, the better the outcomes for our children are going to be. Another thing to think about is that working with kids requires some people find that challenge really entertaining and really effective and really worthwhile, and some find it daunting. But if you're doing juvenile cases, knowing the difference about working with kids and how it is absolutely different from working with adults is important. Whether you enjoy the challenge or not, you got to live up to the challenge. And finally, one of the things we hear a lot is that juvenile appeals coming out of juvenile court are really effective measures of change. And it comes back again to that idea of cultures in a lot of juvenile courts around the country. I'm imagining it's all very different. Where when it's a rotation system where you don't have long-term investment in the juvenile system, whether you're the defender or the prosecutor or the judge, people are falling into this, let's help kids, let's not involve due process. And a lot of people aren't on their A game legally. And the juvenile defender is the one that's on their A game legally, the one that's injected into the Constitution, and Fourth Amendment analysis of the certain proceedings. They can really catch other people not doing it and get a good record for appeals. And those appeals have effect far beyond juvenile court. The Fourth Amendment appeal out of juvenile court will still have effect in adult court. And you can really affect the laws that you don't like in adult court by going through some really good work in juvenile court. So let's go back to the beginnings. This is a picture of Jerry Galt in the military uniform. In Ray Galt, the 1967 case of the Supreme Court that gave the due process right of the kids. And I think due process right is different than the Gideon Sixth Amendment right that was decided 3 years before that. Due process is a broader right. This case didn't talk about just the right to counsel. It talked about the fact that kids have a right to remain silent. They have a right to notice of their charges. They have a right to confront witnesses. They have a right to compel witnesses to do it. They have a right to a whole panoply of adult constitutional rights that weren't being afforded to kids in the before 1967. And the story behind Galt is actually pretty illustrative. He was accused of making obscene phone calls to a neighbor. And he was arrested, his parents were never notified. 2 days later, he was brought in front of a judge on a courtroom in chambers where there was only a probation officer, there was no defense attorney, there were no witnesses, and he was sent to juvenile hall for 7 years for making a phone call. The irony is, if he had been an adult and the same charge, would have carried a maximum of 2 months. And so the Supreme Court said this is just untenable, that we need to do something about it. And it's because juvenile defenders have a unique and purposeful role, and that is to ensure that due process is happening in juvenile court. The Supreme Court in 1967 said this idea of getting services at the expense of due process doesn't serve our kids. It actually leads to arbitrariness. Juvenile records, the juvenile needs the assistance of counsel. It can't be the probation officer, and it can't be the judge that says trust me. I'm going to respect this right. It is the juvenile defender that is responsible for making skilled inquiry into facts, insist on regularity of proceedings, and to ascertain whether he has the defense to prepare and to submit for response. Now, one of my favorite quotes from Galt is, under our Constitution, the shooting of a boy is not justified. And that's absolutely some of the things that we're seeing all across the country. This idea of services in defense of due process because you're a child and because we need to save you is a kangaroo court that the Supreme Court has warned against. Yet 47 years later, after all, we still see pre-Gulf courts operating all over the country. And it's the defender's role to stop it. It's the defender's role to take that on. And I know it's a difficult challenge. And we're faced with judges who say, you can't even make that up. You need to sit down and you can't have it. It's a very difficult thing. But we need to make our records. We need to do what we can to change that culture. And the defender is the person who start. So why do we need to have an expertise? When we talk about it as expertise or specialization, just like capital or appellate, they're different than the average adult criminal case. There are specialties involved with working with kids that if you're not familiar with, you don't know how to utilize in a particularly juvenile case, you're actually not living up to your full potential as a defense attorney. So let's talk about some of those things. You can't have any conversation about juvenile defense or juvenile justice policy without a discussion of adolescent development. And we have whole trainings that go on for 2 to 4 hours on adolescent development. I'm just going to try to cover some basics here so we have the same conversation. But kids are categorically different than adults. And they're different at the time of the alleged offense or the charge, and they're different throughout the entire process of the court system. And you've got to think about their developmental challenges and the developmental differences throughout in both of those contexts. So let's talk a little bit about this diagram. When we talk about developmental science, we really talk about it in 5 domains. It's not one thing. It's not that all kids develop the same way. There are actually 5 kind of spheres of developmental science that interlink, but they are separate and they develop differently. It's reactive. The easy one to start with is physical and biological, the bottom one. That's puberty. Kids develop physically and biologically through puberty, and they all do it differently. We all know that some kids go through puberty very young. Some kids go through puberty quite late. And when kids go through puberty, they're all developing it differently. They have different experiences throughout puberty. And we also know that a 15-year-old going through puberty is very different physically than a 25-year-old. And we can't expect that doctors will be the same. So now we're looking at kids in the justice system, and we want to look at their cognitive capabilities. When we say cognitive, we mean basic intellectual function. The ability to reason, to think, the ability to grasp the meaning of situations that they encounter. This is cognitive development. And what we learn through development science is that kids develop cognitively at very different rates. It's different than intellect. We can all continue to learn throughout our lives, but our cognitive capacity is developing throughout adolescence. And a kid's cognitive capacity may be very different than his biological makeup. How many of us are representing kids who look like they're 25, but they're really only 15? So their biological development is well advanced in their cognitive. And then couple that with things like psychosocial development. What is psychosocial? That's changes in the way that you perceive a social situation or interact with your community. These are things like time, perceptions of time, long-term goals versus short-term goals, ideas of resistance to conformity or complicity to authority. Peer pressure is a huge one under psychosocial development. The science and the studies show that kids are far more susceptible to peer pressure than adults. And they take far greater risks when they're with their peers than they do when they're by themselves. So and emotional capacities, how kids can regulate their behavior and regulate their emotions and their reactions to situations, that all develops. So why do I go through this? Why do I go through this? It's because think of the clients that you've represented or used in court. How many have you been in front of a judge and said, if you're a smart kid, I don't understand why you're acting this way. Well, a smart kid, capacity, cognitive, yeah, he may be a smart kid, but he's psychosocially immature. That's why he's laughing in court inappropriately. That's why no matter how many times you tell him, you need to call the judge sir or ma'am, he can't get it right. He's not paying it. It is not because he's being defiant. It is because developmentally, he's not there anymore. And we need to help our court systems understand this is normal. This is normative child behavior. And to penalize this because we're angry with them being normal is a problem. Now, I'm not saying criminality is normal. I'm saying risk-taking. And I'm not trying to, it's just needs to be mitigation. It needs to be contextual. But these kids are not necessarily bad apples. These kids are developing in a way that all kids develop, and you can take that into consideration. Now, when I say normal, there are lots of things that can negatively impact positive development. And things like learning, cognitive, and emotional disabilities. How many of these kids in the juvenile justice system have learning disability and individualized education? Okay? Those things are negatively impacting their cognitive and their psychosocial and their emotional. And it's making it develop at a slower rate and not as even when it develops, not as fully developed. Kids with mental health disorders are also being negatively impacted in their psychosocial, their cognitive, and their emotional development. Trauma and victimization is an entire network, the National Child Traumatic Stress Network that I put up there, that talks about how trauma and prior victimization affects kids and their involvement in the juvenile justice system, and what courts need to know to actually be trauma-informed caregivers. And then there's this idea of the nature of the home and community. There's been a lot of social science research on how exposure to violence, both in your home and your community, can negatively impact your psychosocial development. So, seeing a lot of violence in your life can make your emotional, and cognitive, and psychosocial development a lot less advanced than other people. And so these are things that we need to start knowing about our kids, and we need to be able to contextualize to our children and to our prosecutor, to our probation officer, to say, this kid is not this bad act. This kid is someone who's going through a lot, and that we need to, if we're really going to be a rehabilitative system, we need to address these things, not just lock this in. And as many things in law, the higher ends starting to get this. The Supreme Court has done a lot of good work in the last decade on adolescent development and put it into law. Starting back in 2005 with Brooke v. Simmons, the case that abolished the death penalty for juveniles. The thinking behind that, the reasoning in the case was that you can't impose the most severe punishment on a child because they are by nature inherently reckless and immature, which will grow out of it. They're more susceptible to peer pressure than adults. You can't hold them to the same level of responsibility. And the developing nature of kids is transient. They are going to get better. And to say now that this young child is subject to the most severe penalty and can never get better is just not in line with science. And then in 2010, Graham v. Florida took that same reasoning and took it away. It's not just the death penalty. That's juvenile life without parole for any non-homicide case. You can't impose that on a child for all those same reasons. And then in 2011, we had a very interesting case called JD v. Mercy on Development. And what that said is it took developmental science and actually put it into a trial and into an interrogation and said, that a child who lacks experience, perspective, and judgment to recognize and avoid choices that can be detrimental to them, that needs to be taken into consideration when interrogating a child. So the issue was this child in custody for purposes of Miranda? Did Miranda have to be given? And they were using the court in North Carolina was using the gold standard, reasonable adult, reasonable person standard, that this person is a community. And they weren't taking into consideration the child. And the Supreme Court did that wrong. That the child would not feel, that a child feel reasonably free to leave is different, especially when it happened in a school. A child was in school being interrogated by or questioned by a police officer. And they said it wasn't custody because the door wasn't locked. Because the child would have ignored the police officer and walked back to class. Well, we all know that's true. The Supreme Court says, yeah, that's not true. Okay, no child would have helped. And so it's taking these issues and putting them into a trial context. And then most recently in Miller v. Alabama, they abolished the mandatory life without parole in all. And so the idea behind that is important to recognize is life without parole is not completely gone, it's just a mandatory one. But the idea behind that is that children deserve individualized assessments of who they are and where they can go. And any mandatory law that provides a cookie cutter of what a penalty should be for a child isn't appropriate. And that's something that we should be extending into our juvenile advocates. It's not just like the law of parole. It should be about any cookie cutter program. It's not taking my child's developmental considerations into the consideration process. Now, these developments in social science have done some really great things across the country. And here's just some examples of things that a better understanding of development science has done. States like Colorado, Maine, Pennsylvania, Virginia, Indiana have started removing kids from adult prisons. Previously, they were keeping kids in adult prisons, maybe separated by sight and sound, like the laws that, but not for proper services. And so, understanding developmental science, they removed these things back. In states like Connecticut, Illinois, Mississippi, Missouri, and Oklahoma, they've raised their age. These states previously did not have 18 as the age of jurisdiction in juvenile courts. Now they do. They moved that up, so I think we're a little bit more advanced here in South Dakota than those states were. But it's an important idea that kids under 18 shouldn't be held to an adult standard. And then that also affected transfer laws in a lot of states. States like Arizona, Colorado, Connecticut, where they've changed their transfer law. They've removed direct buyout from anyone. That it's up to the judge now to decide whether waivers for adult court can happen on an individual basis. It can't be a prosecutorial decision based on some other motive. And then the other one, it kind of looks like the class out there, but it doesn't happen. Using adolescent development and the understanding of impact on trauma and victimization of kids has moved a lot of states away from this idea of indiscriminately shackled. I don't know in South Dakota, do you all see kids shackled in juvenile court? Okay, so I'm not going to play with one, but what happens in many states is that kids are full belly chains, full leg chains, tied together leg chains between them, and in handcuffs the entire time. And that doesn't happen in adult court, but it happens to every kid who comes to the court. And so the idea that that is developmentally damaging, it's starting to make sense. So what's the benefit of having expertise in this kind of developmental science as current? Well, it has lasting impacts on the legal mechanisms like consent. Let's think about consent. If a child, as studies show, is more susceptible to coercion than adult, then is consent viable when you're in a school and a principal or a police officer says, let me see what's in your pocket? And most prosecutors and judges say, well, that was consensual. No. But could he really? Could she have really just walked away and gone back in the box? This idea from JDB that we have to take a child's age into consideration in circumstances, because all of these things are just child circumstances. So let's infuse adolescent development into those conversations. A plea is what? It's a waiver of your right to trial. And a waiver of your right to trial, or any right, the right to remain silent, all of that is affected by adolescent development. Because this child knowingly, voluntarily, and intelligently give up that right. And do they do it with a full understanding of the consequences, short and long term? What kids understand short-term and long-term, and what kids do to get short-term benefits versus long-term obligations is very different. And we need to talk about pleas and waiver of rights differently. And so, in an interrogation situation, well, I read his Miranda rights, he signed it. Okay, first of all, how old is this kid? In your jurisdiction, Miranda is written at what education? Many of them, it's 8 or above. And so if your kid is not in the 8th grade, the average kid has a problem. If your kid has cognitive problems, did this kid even understand those things? Another thing we're learning a lot about is that the instances of language impairment for kids in the justice system is 5 times that of the average, of the general population. And so kids who can't read and write, or kids who can't understand conversations the same way, are kids that are finding themselves in the criminal justice system. How does that impact things like they're able to write? It's also important in things like elements of crime, as mens rea. When you have specific intent crime, where a child is supposed to pretend something, adolescent development, background, maybe negate some of these things. Reckless is another one. The idea of recklessness often requires some level of foreseeability. And if kids, by the science show, can't necessarily appreciate the consequences of their actions because they don't think they're long term, can a child actually criminally be reckless if they can't disregard potential consequences or inevitable consequences? I think these are things that we need to be raising in our report for children when the elements come up. Some good points of the law in South Dakota are that you are one of the few states that has a minimum age of jurisdiction. No child under the age of 10 can be prosecuted. And that's a recognition by your legislature that kids under 10 really aren't capable of living.